Welcome to the Pennsylvania Case Law Update While You Drive podcast. You give us less than 20 minutes per week, we will make sure you never miss changes in the law. This week's episode is brought to you by the McShane Firm. For nearly 20 years, the attorneys of the McShane Firm have been trusted by our neighbors and our friends to represent them in DUI and criminal law cases.
Welcome to Episode 5. I'm your host, Katie McShane, and today we cover cases decided between July 15th and July 21st, 2020. Due to the large number of cases this week, only majority opinions are discussed. Dissenting and concurring opinions will not be addressed. We will start this week with an administrative law case. The Supreme Court decided the issue of what deference a court must give to an administrative agency's interpretation of an enabling statute in the case of Crown Castle. The case involved the Pennsylvania Public Utility Commission interpreting the definition of public utility. The commission was determining if a distributed antenna system, or a DAS, was considered a public utility. In coming to this conclusion, they added language to the statute interpreting whether the DAS was a public utility. The court found that it was improper for the commission to add language in interpreting a statute when the statute's plain language is clear. The court further held that they need not give any deference to the agency's interpretation due to the unambiguous language in the statute. The court also concluded that a DAS did meet the definition of a public utility and overturned the commission's ruling that a DAS was not a public utility. Up next is a civil procedure case. At issue before the Supreme Court in the case of Temple v. Providence Care Center is whether failure to preserve an issue at trial can be used to grant a new trial in a post-sentence motion, and whether in absence of a preserved issue, the court can sua sponte, meaning on its own without motion from either party, grant a new trial. During the trial, numerous objections were raised by Providence, but they were never requested a mistrial. Only after the verdict did they request a mistrial. The court granted the request for a new trial on the basis that the trial was not fair. The Superior Court found that it was improper for Providence to request a mistrial in its post-sentence motion as it was not an issue preserved at trial, but concluded that the court could sua sponte grant the mistrial. The Supreme Court agreed with the Superior Court in that Providence did not preserve the right to request a mistrial by failing to do so during trial. The Supreme Court overturned the Superior Court on the issue of the trial court sua sponte granting a mistrial. First, the Supreme Court found that this is not what the trial court did, but rather ruled on Providence's post-sentence motion, which was improper as the issue was not preserved during trial. Further, the Supreme Court held that the court can only grant a mistrial when either party fails to raise the issue when there is an exceedingly clear error that results in manifest injustice. It is a very high standard which should be used only in rare circumstances and was not met in this case. There were several criminal cases decided this week. In the criminal case of Commonwealth v. Talley, the defendant was convicted of 2 counts of stalking. The defendant raised 3 issues on appeal. First, whether Article 1, Section 14 of the Pennsylvania Constitution violates the Due Process Clause of the United States Constitution. The court found that this issue was waived and therefore could not be addressed on appeal. The second issue raised involves the doctrine of merger. The defendant was convicted of 2 counts of stalking under 2 separate subsections of the stalking statute. He argued that he was being twice punished for the same criminal act. Sentences must be merged only when all crimes arise from a single act and all elements of one offense are included in the elements of the other. Here, the court found that the evidence was sufficient to establish that the convictions did not arise from a single criminal act and therefore merger was not required. In his final issue, the defendant claims that screenshots of text messages violated the best evidence rule. The best evidence rule says that an original writing, recording, or photograph is required to prove its contents unless rules or statutes provide otherwise. The defendant contends that the photographs violate the best evidence rule because they do not contain some of the metadata that would be provided by a full forensic download of the text messages. The court found that the victim was able to authenticate the contents of the text messages and that because the underlying metadata was not essential to establish the content of the writing, the photographs did not violate the best evidence rule. In the case of Commonwealth v. McClelland, the Supreme Court overruled prior case law in Commonwealth v. Ricker and held that the plurality opinion in Commonwealth ex rel. Buchanan v. Verbonitz that hearsay evidence alone is insufficient to establish a prima facie case at a preliminary hearing is binding precedent. In the majority opinion, the court held that while hearsay may be permitted in a preliminary hearing to establish some of the elements of the crime charged, a case cannot be established on hearsay evidence alone. Commonwealth v. Hamlett addresses the issue of whether an appellate court can sua sponte make a rule of harmless error when the issue is not raised or proven by the Commonwealth. The court held that the availability of a sua sponte review in appropriate cases serves as an exception to the ordinary rule that the government bears the burden of persuasion relative to harmless error. While the court should not use the sua sponte determination of harmless error lightly, it is appropriate in situations when it does nothing more than affirm a valid judgment of sentence on an alternative basis. In the case of Commonwealth versus Wolfel, the underlying case was about admissibility of blood tests in a case and the implications of Birchfield, the 2016 U.S. Supreme Court case that said a driver cannot be criminally penalized for refusing a warrantless blood test. However, the only real issue addressed by the Pennsylvania Supreme Court in this case is issue preservation, meaning was the issue raised in the sufficient time and place in order for the Supreme Court to be able to consider the issue. The defendant, Wolfel, initially filed a suppression motion to exclude her blood results following the decision in Birchfield. The trial court granted suppression and cited state constitutional grounds, even though Wolfel had only raised federal constitutional grounds. The Commonwealth appealed. The Superior Court reversed the suppression ruling on the basis that Wolfel had waived any argument regarding state constitution grounds when she only raised federal constitution arguments. Wolfel appealed to the Supreme Court, bringing us to the instant case. The Supreme Court reversed the Superior Court decision, again on issue preservation considerations. The Supreme Court reasoned that the Commonwealth waived its challenge to Wolfel's failure to raise a claim under the state constitution by failing to challenge the trial court's explicit invocation of that provision before the Superior Court. The Supreme Court thereby reversed the ruling of the Superior Court and reinstated the trial court's suppression order. Commonwealth v. Smith addresses a single issue, whether a person who is subject to an active bench warrant is considered a fugitive from justice for purposes of the law that prohibits a fugitive from possessing a firearm. Because fugitive from justice is not defined in the statute, the court was required to discern the meaning for purposes of the statute prohibiting possession. The court found that a person who is subject to an active bench warrant is in fact a fugitive from justice, even if they are not actively fleeing at the time of the contact. There are some interesting issues raised, but not directly addressed by the court. The full case text is linked in the notes if you're interested. The case of Commonwealth v. King addresses whether informal notice to seek an aggravated range sentence of 20 to 40 years for attempted murder resulting in serious bodily injury is sufficient or whether formal notice is required. In this case, the court found that while notice was not formally in writing and it was not formally charged as an aggravated range, based on the circumstances, the informal notice was sufficient. In this case, the defendant had rejected a plea offer, and at that time, he was advised that the minimum sentence was 17 and a half years and the maximum sentence was 40 years. Additionally, the information did allege serious bodily injury in the charge for aggravated assault. Further, the jury specifically found, by indicating on their verdict slip, that the element of serious bodily injury resulted from the attempted murder, and therefore the aggravated range sentence was appropriate. The second issue addressed by the Supreme Court was whether consecutive sentences for conspiracy and attempted murder, which arose out of the same incident, was proper. Per the plain language of the statute, a defendant may not be convicted of more than one inchoate, meaning attempt, solicitation, or conspiracy, for conduct designed to culminate in the commission of the same crime. In other words, you cannot be convicted of attempted murder and conspiracy to commit murder when both are intended to result in the same crime. In this case, the defendant was convicted of conspiracy to commit aggravated assault as well as attempted murder. The court held that the statute precludes multiple sentences because there is no possibility that the conspiracy to commit aggravated assault existed independently of any conspiracy to kill. Because only one conspiratorial agreement existed, he can only be punished once. In the case of Commonwealth v. Montgomery, the Supreme Court addresses whether a handgun partially tucked into a waistband, leaving the weapon's handle visible, was concealed for purposes of the crime of carrying a concealed weapon without a license. The Supreme Court concluded that the determination of whether a firearm is concealed for purposes of the law is extremely fact-intensive and is a question for the jury to determine based on the totality of the circumstances. The court stated that one carries a firearm concealed on or about his person in violation of the law when viewed in the totality of the circumstances. He or she carries the firearm in such a manner as to hide the firearm from ordinary observation. Absolute invisibility to others is not required. The court declined to issue a bright-line rule and instead found that the concealment of a firearm is a question for the jury to decide. We'll be right back after a brief note from our sponsors.
This segment of Pennsylvania Case Law While You Drive podcast is sponsored by the McShane Firm. The McShane Firm is Pennsylvania's largest and best DUI and criminal law firm. Their mission is simple: make sure the presumed to be innocent remain innocent.
Welcome back. In the consolidated appeals of Commonwealth v. Witmayer and Commonwealth v. Lacombe, the Supreme Court addresses whether retroactive application of the Sex Offender Registration and Notification Act, or SORNA, is punitive and an unconstitutional ex post facto law. An ex post facto law is a law that changes a legal status or consequence after it has already been done. In both of these cases, the defendants were convicted of a sex crime that occurred before SORNA was passed. Following the passage of SORNA, each of the defendants was classified as a Tier 3 offender requiring lifetime registration. Both appealed their lifetime registration requirements. As a procedural first step, the court first found that the PCRA is not the exclusive mechanism for challenging sexual offender registration, and therefore the court does have jurisdiction to hear the claim even when filed outside the scope of the PCRA. Substantively, the court found that Subchapter 1 of SORNA was not punitive in its intent and instead is directed at protecting and informing the public regarding sexual offenders and is therefore not a violation of the ex post facto law. In a labor law case, the Ellwood City Community Health Foundation filed a petition to approve separation from the foundation and the ECH legacy following a transfer of assets to AmeriCorps. The Orphans Court, following a hearing, denied the petition for separation. At issue in this case is the funding of the pension plan. If separation were approved, ECH legacy would have no obligation to continue funding the pension plan. The court evaluated ERISA, or the Employee Retirement Income Security Act, a statute designed to promote the interests of employees and their beneficiaries in employment benefit plans, and found that ECH legacy had satisfied all of its funding obligations with respect to required contributions. There was no evidence to suggest that ECH legacy failed to make any required contributions. The court further found that when AmeriCorps purchased the assets, they became the pension plan sponsor and would be responsible for any future contributions. As ECH legacy had met its contribution requirements, the Commonwealth Court overturned the opinion of Orphans Court and approved the separation. The case of Charlton versus Troy is a medical malpractice case which began after Charlton gave birth to twins at Delaware County Memorial Hospital. Dr. Troy was the doctor who delivered the twins. Charlton, the plaintiff, sued both the delivery doctor and the hospital, the defendants, after one of the twins was born with spinal cord damage. The plaintiff's position at trial was that the damage was caused during birth due to a breach in the standard of care. The defendants claimed that the damage was caused prior to delivery. The jury found in favor of the plaintiff. The defendants appealed. The first issue addressed by the Superior Court was whether or not the plaintiff presented sufficient evidence to establish that the doctor breached a medically accepted standard of care. The Superior Court found that there was sufficient evidence presented as to one standard of care, but not as to the alternative theory. However, as the defense did not ask for a specific verdict form to determine which theory they based their verdict on, the verdict could not be disturbed. The second issue addressed was whether or not the hospital, who did not employ the doctor, could be liable. The court found that there was sufficient evidence presented to establish liability on the part of the hospital. The third issue addressed was dispositive in this case. During trial, the plaintiff, over repeated objections by defense, read directly from a book about neonatal neurology regarding a popping sound and that being indicative of spinal cord injury during birth. They used the text both during direct and cross-examination. The plaintiff also cited the text as substantive evidence in their closing argument. The defense repeatedly objected to hearsay as well as lack of foundation, but were overruled each time. To constitute reversible error, an evidentiary ruling must not only be erroneous, but also harmful or prejudicial to the complaining party. The Superior Court found that the admission of the text from the book was hearsay and should not have been admitted at trial. The court further found that the admission of the text was extremely prejudicial to the defendant. As a result, the judgment from trial court was vacated and it was remanded or sent back to the trial court for a new trial. Lageman versus Zepp is another medical malpractice case, this time discussing the doctrine of res ipsa loquitur, a Latin phrase meaning the thing speaks for itself. The plaintiff suffered a stroke following a routine procedure of placing a central line. During the trial, through presentation of expert testimony, the plaintiff alleged that the defendant was negligent in his placement of the central line and that negligence was the cause of the injury, and also that placing a central line into an artery rather than a vein does not typically occur absent negligence. The defendant alleged that he was not negligent and that these types of injuries can occur without negligence. At trial, the plaintiff requested but was denied the res ipsa loquitur instruction. Res ipsa loquitur is an evidentiary doctrine permitting the jury to infer negligence and causation from the mere occurrence of the event and the defendant's relation to it. A res ipsa loquitur instruction may be given to the jury when the following three prongs are met. 1. The event is the kind of which ordinarily does not occur in the absence of negligence. 2. Other responsible causes, including the conduct of the plaintiff and third persons, are sufficiently eliminated by evidence. And 3. The indicated negligence is within the scope of the defendant's duty to the plaintiff. The trial court denied the instruction, stating that the particular facts of the case would not present the type of event that is so obvious that a mistake can occur but for negligence happening. At the conclusion of the jury trial, the jury found in favor of the defendant. The Superior Court found that the plaintiff had in fact satisfied all three prongs required to instruct the jury on res ipsa loquitur. As such, the trial court's denial of the instruction is reversible error, and the judgment is vacated and the case remanded for a new trial. The next area of law is separation of powers. In the case of Renner versus the Court of Common Pleas of Lehigh County, the Supreme Court considers whether the application of the Pennsylvania Human Relations Act, the PHRA, to the judiciary violates separation of powers. Appellant Renner was a parole officer for Lehigh County. He was terminated following a series of alleged harassment and discrimination events. He filed suit claiming his termination violated the PHRA. The Supreme Court held that application of the PHRA to judiciary personnel is in direct conflict with the judiciary's constitutionally granted exclusive and independent right to administer the courts and to promulgate rules and policies regarding judicial employees, as well as its exclusive and independent authority to select, discharge, and supervise its employees. As such, application of the PHRA to the judiciary violates separation of powers, and that the appellant must instead process his claims of harassment and discrimination under the Code of Conduct with respect to county-level court employees. We next address a tax case in Kuharchik Construction versus Commonwealth of Pennsylvania. Kuharchik, the plaintiff, is an independent construction contractor who does contract work for the Commonwealth. On a tax audit for work done between 2011 and 2014, they were assessed a use tax for which they contested a significant portion, claiming that some of the contested items, specifically traffic signals and their supporting structural parts, were exempted from the use tax because they're considered building machinery and equipment, or BME. For the remaining contested items, the plaintiff argued the Commonwealth was equitably estopped from taxing the items as they had not been previously taxed on similar items in a prior audit. This lawsuit followed. With regard to the BME and the traffic signals, the court evaluated the BME statute, which includes the term traffic signal, and concluded that the language in the statute is vague, and in evaluating the plain meaning of the words, the supporting structure must be included, and the signal light itself would not operate or function without its supporting structure. Therefore, use taxes did not have to be paid as to the traffic signals and supporting structural items. As to the remaining items, the court found that the Commonwealth was not equitably estopped from claiming taxes even though they did not do so in the past, and that use tax must be paid. The final area of law today is wrongful death. In the case of Maas versus UPMC, the Supreme Court addresses whether a mental health provider has a duty to warn individuals who may be the subject of their patient's threats. In this case, the patient had made threats to kill his neighbors. He lived on the 4th floor of an apartment complex. At trial, UPMC, the mental health provider, moved for summary judgment, meaning asking the court to dismiss the case without trial, on the basis that they had no obligation to warn the neighbors because they were not identified by name and it was too amorphous to determine who should be warned. The trial court denied the motion for summary judgment. The case was appealed to the Superior Court, who affirmed the opinion of the trial court. This appeal was then brought before the Supreme Court. The Supreme Court ruled that the mental health provider did owe a duty to warn the neighbors because though they were not identified specifically by name, they were a readily identifiable group based on the context of the statements as they were made to the mental health provider. In the case of Walsh versus BASF, the estate of Walsh brought a wrongful death suit against BASF Corporation after Walsh died from cancer. Walsh's estate argued that his cancer was caused by repeated exposure to a number of pesticides while working as a groundskeeper for a golf course. There are 3 issues raised in this appeal to the Supreme Court. First, what is the proper role of the trial court in a Frye hearing? A Frye hearing is to establish whether or not an expert's methodology is generally accepted in the relevant field. Second, whether the Superior Court's opinion committed error by eliminating the plaintiff's burden to show that a specific pesticide, not just a class of pesticides, caused the injury. And third, whether the Superior Court failed to establish how the trial court abused its discretion. The Supreme Court held that in regards to a Frye hearing, it is the trial court's proper function to ensure that the expert has applied a generally accepted scientific methodology to reach his scientific conclusion. The court must be guided by scientists in the relevant field. Conversely, trial courts may not question the merits of the expert's scientific theories, techniques, or conclusions, and it is no part of the trial court's function to assess whether it considers those theories, techniques, or conclusions to be accurate and reliable. The trial court is strictly limited to determining whether the expert's methodology is generally accepted in the relevant field. As to Issue 2, the Supreme Court found that the Superior Court did not eliminate the plaintiff's burden and the plaintiff must still show specific causation. And finally, the Supreme Court found that the Superior Court properly found that the trial court abused its discretion, despite not using the precise magic words. The case is remanded to the trial court and an opportunity is given to the defendants to renew their Frye motions to address relevant issues in accordance with this opinion.
Thank you for listening to the Pennsylvania Case Law Update While You Drive podcast. Be sure to subscribe to this podcast and our YouTube channel to make sure that you are always in the know when it comes to important changes in Pennsylvania case law. We want to thank this week's sponsor, the McShane Firm. The McShane Firm is a central Pennsylvania fixture when it comes to DUI and criminal defense. The attorneys and staff at the McShane Firm believe in good old-fashioned central Pennsylvania values like hard work and straight talking. Give them a call if you or a loved one ever needs help.